Good morning, good afternoon, and good evening to everybody, regardless of where you're joining from or perhaps watching this session live, the recording later today. My name is Erin Cronjé. I am one of the directors of Africa in the Moot and a senior associate at Brauw Blackstone Westbroek in Amsterdam. Africa in the Moot is a non-profit volunteer-based organization that supports sub-Saharan African teams to participate in the Vis Moot, and we do so with great pride and pleasure. I am joined today by Miss Annie Adikin, one of our superstars of Africa in the Moot, a former Mootie of the Makerere University team in Uganda last year. I must mention, because she is indeed very modest, that she was also the best oralist at the pre-Moot that is hosted by Africa in the Moot each year, earlier this year. And she is currently a coach of the Makerere team as well, so she is indeed paying it forward. And amongst many of her other achievements in the present and to come, she is also the editor of the Makerere University Journal. We are today discussing views from the bench. So what does that peculiar phrase mean? Well, I understand that the Mooties are hard at work with preparing their claimant's memoranda, and I hope they're starting to prepare the respondent's memoranda as well. And that may be a taxing and confusing process. I hope you have not scratched your heads too much, and I hope you still have not pulled all your hair out in the process. But ultimately, what we are trying to help you with today is to put in context what you are doing. So as you may have understood so far in the process, arbitration and indeed many court proceedings are about persuasion and persuading your tribunal. So our speaker today will be giving you some very helpful tips on what you need to consider as you are completing your writing process, and also as you can think about when you transition shortly into the oral advocacy preparation phase. And now with that, let me introduce you to our speaker. I had mentioned that he is a dear colleague of mine. I have the great privilege to work with him at Brauw Blackstone Westbroek, where he is a partner. But Matthias Kuscher is not just a partner at Brauw Blackstone Westbroek. We have to look a little bit further back in his very extensive resume to understand why he may be even more enticing for those of you who are on the call, to understand why his expertise is so special and so helpful to what you are about to endure for the remainder of your Vis Moot period. So he is a highly accomplished advocate. He has been, I think I will spare you all the acronyms of the many, many arbitral institutions in which he has been a participant and a counsel. But prior to joining de Brauw, he was in fact the legal counsel to the Permanent Court of Arbitration, which is the PCA in The Hague, and in fact established the PCA's first overseas mission, which was as the inaugural PCA representative and legal officer in the Republic of Mauritius. So I'm sure our Mauritius team will probably know his name and know some of his colleagues that work there as well. He has also acted in many, many arbitrations between states and state-owned entities as a tribunal secretary and also private parties. And he was also the counsel in charge of the UK and Commonwealth team at the ICC in Paris. So I hope that all of you on the video know enough in your research by now to know what the ICC is, because those, of course, are the rules that are applicable to this year's Moot problem. And in that process of working with the ICC, he has had the great experience of supervising hundreds of arbitrations and scrutinizing over 100 arbitral awards. And in addition, again, I said I would keep it short, and this is really my best effort to keep this short. He has also taught at the universities of Cambridge, Heidelberg, Krakow, and the LSE. So with that, I now stop talking and I hand over to Matthias to illuminate you. Thank you very much, Matthias.
Well, thank you very much, Erin, for this overly generous introduction. And what Erin forgot to say is that, well, Annie is one of the superstars of Africa in the Moot. Erin is too, for without her, we wouldn't be here, and I wouldn't be having the great privilege of trying to teach you a little bit about what you might think when you are on the bench and how that perspective might help you on your journey through the Moot and through advocacy more generally. Now I will try and somehow show you the presentation because the view from the bench, as this little slide shows, is generally a jungle. And your job as an advocate is to help me find my way through the jungle. That is going to be my ambition tonight, this afternoon, to show you what tools you might want to use to impress those people on the bench and lead them out of the jungle. Now, before I do so, I wanted to briefly introduce this presentation by giving a series of disclaimers. And they're all designed to convince you that you should not take this presentation all too seriously. I realize that is a strange thing to say for a speaker, but it is heartfelt. Now, why should you not take this presentation too seriously? The first has to do with timing. I glanced at the moot court problem and the rules, and I realized that you're all a mere 10 days or so away from submitting your memorial for the claimant. So all I can teach you tonight or this afternoon is merely designed to assist you in that process of getting your first brief over the finish line. Don't take anything I say as gospel. Don't be tempted to completely revamp everything. Stay on track and see if you can derive any benefit from following a few of the tips that I have to offer. The second has to do with the inherently subjective nature of views being offered from the bench. Your memorials and your advocacy performance in Vienna will not be reviewed by a homogeneous group of robots. Instead, the Vis nowadays attracts some 800 or more arbitrators, and they're almost as diverse as the teams that participate in the moot. So whatever I might have to say about my personal views from the bench might be completely insane from the perspective of another arbitrator. So you have to find in your teams and in your process of finishing your memoranda a way of taking into account what I say, but not giving it too much weight. Unlike in a national court, where you might know precisely who your judge will be, and you might spend a great amount of time thinking about what might impress that particular judge, that luxury the moot does not afford you. And finally, because this is a moot, it is a tiny bit artificial. You are given a closed universe of facts and evidence. You are put in a certain procedural posture, and you can't do anything about that. Now, that constrains you both in what you can argue and what you can say, but also in how you can say it. You're forced to make certain choices that in a real arbitration, you might not have to make quite in the same way. So, by all means, stay online. I look forward to having a lively exchange with you. But as I said, don't take anything I say too seriously. Now, very briefly, two preliminary questions that I think you might want to ask yourselves again as you close in on the final lap on the race towards the memorandum for claimant. It's always good to make sure that you remind any reader, any arbitrator, any listener, who exactly you are and what you're therefore doing. Don't forget your identity, and that doesn't have anything deeper, but it simply means don't forget that you are the claimant or the applicant, and that you might, in some future point, be the respondent. Don't forget exactly what procedural posture you are taking. Are you making an application? Are you resisting an application? Are you inviting a tribunal to exercise discretion, or are you asking them to apply a different type of rule? And thirdly, don't lose sight of the soft factors. It is a very different thing if you are acting as counsel for a big multinational corporation in an arbitration against a small, medium-sized local enterprise. And you might be able to use both your own identity and the soft factors connected to that as much as those of your opponent. Now, what it is that you're doing, Erin already alluded to, but fundamentally, you are asking three arbitrators to do something for your client. And while it's right that your principal job is to convince them that they should do so, I would submit to you that you should adopt a slightly different position, namely that your job is to help me. And why is that so important? Well, because I need to follow you out of the jungle. You can convince me that I should leave the jungle, and I would wholeheartedly agree. But if you don't show me the way in a respectful, intelligent way, I'm unlikely to follow you, however much I'm convinced of the need to leave the jungle. That isn't to say that you should be obsequious and sycophantic, but think of everything you do as trying to make the tribunal's life easier. And we'll come back to that theme when we look at what I will call the 5 golden oldies in a minute. Finally, remember what I just said about your audience and how little you know and how little you can assume about them. In an ordinary arbitration, of course, you would know your audience. You would have likely picked at least one of them yourselves. But in the Vis Moot, all you know is that your memoranda and your performances in Vienna will be seen by a very diverse international group that is exceedingly heterogeneous. They won't all be civil lawyers, they won't all be common lawyers, they won't all be arbitration practitioners. They'll be from all 4 corners of the world. And that is part of the fun. As such, I would caution you against making any rash judgments as to what is the most compelling course of action. The educational goal behind the Vis, I suppose, is to also teach you that international arbitration in its true sense is supposed to transcend those boundaries between civil law and common law, and that not one legal tradition is inherently superior or more likely to yield a certain outcome. That is not a purely educational exercise. That happens to accord with reality. Because in practice later on, you will be drawing on that very diverse, very international pool to find your own arbitrators. And you will likely be equally unable to simply follow the way in which you would perhaps want to prosecute and win a piece of litigation in your local courts. When fashioning your arguments, there are 2 further qualities of arbitrators that you should remember in any event, and that is true both for the Vis arbitrators and the real ones. Inherently, an arbitral tribunal is non-permanent. You're not making submissions to a court, much less a court of final resort or Supreme Court. You're making submissions to a group of 3 people whose only job is to look at this one case. That may create a certain shift in the mindset, whereas a Supreme Court justice may have institutional views and interests to bear in mind. That is less likely to be the case for an arbitrator. That is coupled with arbitrators being fairly unconstrained. That's not to say that arbitration is lawless, but unlike in the national court system, there is no formal mechanism of direct appellate review. You will all know by now that you have ways of taking recourse against an award. But unlike in a national court system, you're not dealing with a first instance judge who might be concerned about being overturned on appeal, who might even be thinking about his own progression or her own progression in the court system and his chances to perhaps be elevated to a higher court. That is something which is unlikely to resonate with arbitrators. And that is because, as I said, what they're doing is, on the one hand side, very similar to what a judge does, that they're going to give one party what it wants, they're going to decide the case, but their perspective is limited to this one case and one case only, at least insofar as their decision is concerned. That isn't to say that arbitrators don't have their own interests and incentives that operate upon them. They're slightly different, though, from the ones that might operate on a judge. Now, obviously, an arbitrator wants to do a good job, doesn't want to see her award set aside. At the same time, an arbitrator might also be concerned about being reappointed. in the next case and the one after that, impressing the parties with the way they've handled the case. And I suppose they also have an interest in making sure that arbitration is seen to be working, to be living up to the promises that you may have read about in a book or two. Now, against that background, let me remind you of something the late, great Justice Scalia said, which is, I would suggest, true as much for judges as it is for arbitrators. Namely that inevitably, and whatever rule a judge or an arbitrator is applying, fundamentally, the outcome they're going to reach is supposed to be fair, and it's supposed to be the result of the application of a legal rule that will produce similarly fair and predictable results in future cases. Bear that in mind when you test your arguments and the rules you say should be applied. Do they satisfy those two conditions? If they don't, you have an especially complicated task of advocacy to do, because it is always more difficult to convince a judge that a rule has a harsh edge. That might be so, and in some cases it might be unavoidable, but you'll have a much easier time of prevailing if you can convince a judge that the rule is both clear, that it yields a certain result, and that result also happens to be fair in all the circumstances. And let's see how you might go about doing that. And I've identified for your reference 5 golden oldies, tips that I'm sure you're not hearing for the first time, but perhaps it's good to restate them and see how they apply with particular force in the Vis Moot. Here they are. The first golden oldie is know your case and your opponent's case, naturally. Be accurate about it and never overstate what is in the case. The second golden oldie is that you should know the relevant standard of decision and live by it religiously. The third golden oldie is that you must only defend the defensible terrain. You must yield indefensible terrain ostentatiously and concentrate your fire. The fourth golden oldie is that you should always formulate and apply your major premises with great rigor and precision. And fifth, in presenting your arguments, use the relevant text, precedent, practice, and policy, and preferably in that order, if you can all marshal them. Let's look at them one by one. Now, by now you know that for you, unlike for a practicing lawyer, the factual universe is closed. All of the facts that you need or you could possibly want are contained in the bundle that you were given. Critically, and I think that's sometimes overlooked if you see paragraph 25 of the rules, everything that a party alleges in the bundle is taken to be true or correct unless there is a contradiction between what the claimant and the respondent say. So much like in traditional pleading style advocacy, you can establish what is and what isn't undisputed by careful perusal of the factual record. The other rule that is maybe as important as the first one is that you can't make up stuff. So while you're able to identify what facts are established or undisputed and what are in contention by looking very carefully at the totality of the material in the bundle, and you are allowed to assume that the world is still the world, and therefore you are allowed to rely upon facts that are public and as such true, you cannot, if you will, create evidence or facts that are not within the ambit of paragraph 25. So you should be careful when drafting your statement of facts, when identifying the relevant facts that you need to establish a certain proposition, that you don't stray beyond the boundaries of the problem. Now, when you first get the problem, you may have thought that it is pretty short. It's not a very big file. There are not hundreds and hundreds of exhibits. it is all pretty manageable. But the funny thing about the moot is that a lot of the facts that you might need and that might move the needle on any of the issues that are in play may be somewhat hidden, and it pays off to read and reread the problem, and certainly also the clarifications, to see whether you might have missed something. That is because at the end of the day, this moot, the Vis Moot, is not a competition in which you will get many credits for figuring out some arcane point of law. Moots in common law countries are often fashioned to be appellate moots, where you are making an argument before a fictitious Supreme Court or the House of Lords, and you are having an argument purely on the law, what the law is, what the law should be, and how it should apply in a certain case. The Vis Moot, in a sense, is a first instance moot. So while it's important to get the law right, and we'll come to that, the really critical thing, and the one that will make you win or lose, if you will, in the Vis Moot, is to have the right facts at your fingertips to use them to convince. As Judge Alex Kosinski once said, the law doesn't matter a bit, except as it applies to a particular set of facts. Now, when you are looking at your factual universe, I think you should follow the psychological biases, I think, that most arbitrators share, which is that their best friend, obviously in an adversarial process, are facts that are undisputed. And I just showed you Rule 25, which says that everything which is not denied, which is not contradicted, is said to be true and therefore undisputed. So see to it that you use as much of those undisputed facts as you can. Obviously, given that we're not having an evidentiary hearing being simulated, we're not having you create evidence or lead new evidence, the way to score points is not to try and use a contested fact and make your submission hinge on that, but to find those undisputed facts and show why they are the ones that dispose of the case in your favor. The second piece that every arbitrator will gravitate to, having looked at the undisputed facts, is the contracts or the contract. Why is that? Well, it is the fountain of an arbitrator's jurisdiction. It is why the arbitrator is here. It also happens to be a document on which both parties happily agreed. Now, if you can reason by reference to the contract, and that is not just simply by using the right provisions, but by also looking at the contractual theme as a whole and deriving indications from that as to how the case should be resolved, that is going to be incredibly potent. Third, contemporaneous documents. You have some in the file, letters written at the time, emails, etc., etc. Again, they are seen as helpful by arbitrators if they are used, if they are marshaled, because they are, in a sense, original evidence from a time when there wasn't yet a fight. And they might give much clearer and less adulterated indications of what the parties were thinking, expecting, hoping to do, than whatever might be contained in a witness statement, which is something I've put, for now at least, at number 4. Now, when you're scanning or rescanning the problem for facts that fit the legal rule you say should apply, remember how far you have to take those facts. As I've said, this is not an evidentiary process. You're not trying to establish what is true. That is left, if you will, for a subsequent phase of this arbitration, which you'll never get to see. You're in any event not in a process where you're trying to show that a witness's statement in the bundle is more convincing or compelling than another witness's statement. All you're trying to do is, and we'll come to that in a moment, is to see how a particular test or decision standard should resolve the case in your favor. And for that, you likely don't need to even put the bar as high as saying that you have discovered and established the absolute truth. And I refer to the decision standard for a reason. Because this is a moot, it can't contain many issues, if it contains any, that are completely black and white. If it did, it wouldn't be a moot. If it did, it wouldn't be a dispute, because if everything was clear, or if one side clearly had the better of the argument, the parties likely wouldn't bring the case to arbitration. And you can see that even in the way in which the tribunal has formulated the issues that you are supposed to look at. If we focus on the procedural component and look at the relevant procedural order number 1, both questions are phrased in a way that first emphasizes that you should tell the tribunal whether it can take a certain procedural decision that has to do with power or jurisdiction, if you will, but let's use the word power to avoid confusion. And secondly, whether it should do something, which seems to suggest whether it's desirable or whether discretion ought to be exercised in a certain way. No one is suggesting here, and the tribunal isn't suggesting, that the issues are configured in a way that you might be able to say that they must do something. It seems to be a little more complicated than that. And that is not so strange if you look at the rules and provisions that might be engaged by this year's moot problem. One issue, as you no doubt know by now, has to do with whether or not a party is to be allowed to make a new claim that potentially falls outside the limits of the terms of reference after they have been established. Now, Article 23(4) of the ICC Rules leaves that judgment ultimately to the tribunal. And it doesn't say very much about what the tribunal is supposed to think about when making the decision as to whether or not to allow such a new claim. Leaving aside the preliminary question, or the logical precursor, which is the claim even a new claim? Does the claim even fall outside the limits of the terms of reference? All the tribunal is told when making the ultimate decision is that it should consider various factors, the nature of the new claims, the stage of the arbitration, and other relevant circumstances. In other words, this is the tribunal having procedural discretion, being told to look at essentially everything, or at least everything that's relevant. But you're seeing here a classic device that is a hallmark also of arbitral procedure, which is to say that the tribunal is almost unfettered in the way in which it exercises its discretion. Now, that has an impact on how you will ultimately need to reason through the case, and I'll show you what I think you can do about that in a moment. It's not very different when you look at the other issue, which I will simply call the consolidation point. There, the additional complication, I suppose, is that you have a contractual provision, Article 41 of the Freiburg Agreement, that you might think is engaged. And again, if you look at the terms of that provision, of course, it contains various factors that are relevant and that you have to establish before one can say that the tribunal has a certain power. But it doesn't tell you how the tribunal is supposed to exercise that power, if at all. Likewise, if you were inclined to look at Article 10 of the ICC Rules, which, mind you, applies to what the ICC court is to do, there you see already in the first line that this is a typical may provision. So even if you establish that your case falls into one of the categories of Article 10, all you know is that the court may then consolidate, and in so deciding, it is allowed to take into account whatever circumstances it considers to be relevant. So again, a wide rule of discretion. And that is, as I say, characteristic of many of the procedural issues that you encounter in an arbitration. And it's certainly understandable why the moot court problem drafters have chosen to give you a series of issues that ultimately call for a discretionary judgment. Because, if you will, the sheer range of potential factors and circumstances is so wide that there is hopefully something for everyone. Now, once you've identified your standard of decision, always live by it, believe in it, and implement it. Don't forget about it. If you're asking for a tribunal to exercise discretion in a certain way, you are essentially asking them to say that your client just has the better of the arguments, the balance of convenience, if you will, tips in your client's favor. And there's a whole range of reasons why that can be. Don't put the bar too high for yourself in how you express the rule and how you express the task that you have. And also don't suggest that the tribunal is more constrained than it is. Don't be tempted to argue that the tribunal must follow a certain course when the rules tell the tribunal that it is essentially entitled to do whatever it likes. Now, if you don't believe me, then you should believe someone who has a much bigger brain and a lot more grey hair and far more judicial experience, and that is Lord Sumption, who once memorably said that whatever you call it, a multifactorial test or common sense approach or pragmatic, all those phrases that you see used in judicial decisions, in arbitral awards and procedural orders are ultimately simply code words, euphemisms for the simple phrase, we can do what we like. Now, that is not to say that you are entitled to argue whatever you like. I'll come to that in a moment. But you should remember that arbitrators are, in principle, entitled to do whatever they like, and you have to show them why the course of action that you suggest is the more prudent one. Now, it's always good to learn from those who've come before you, and not everyone can be coached by superstars like Annie. And then you should, I think, for inspiration, look to, for example, the winning memoranda of last year and see whether you can detect there that the techniques I've just explained to you are being used. And on the point of being clear about the relevant standard of decision and its application, I think the winning memorandum for respondent of the last edition of the Moot, authored by the team from Freiburg, is a great example. In that case, there was an application for stay, alternatively bifurcation. And the team went about it in a very clear way by flagging at the outset that this was a matter of discretion, that the arbitral tribunal had discretion to stay or bifurcate the proceedings. And it then told the tribunal what the tribunal's task was in exercising that discretion and what it should do to decide how to exercise that discretion. Think about your own memorandum. Think about the issues that you are dealing with, and make sure that you are always clear on what sort of power you're asking the tribunal to exercise and what the relevant factors or elements are that you think should helpfully be taken into account. The third golden oldie is one that is always brought up and rarely followed, which is frustrating, but perhaps understandable because we're all lawyers, we like to be right and we like to fight. But like any good general going into battle, you should not set yourself up for failure by trying to defend completely indefensible propositions. That is not only going to end in disaster, but it's also going to be painful and unhelpful from your client's perspective. Now, what am I trying to tell you to do? What does it mean to only defend defensible terrain and to concentrate your fire there? Well, the what is answered relatively easily. I think, given that this is a first instance case, if you will, an arbitration before a tribunal, not an appellate case, and you're asking for a procedural ruling based on an exercise of discretion against the background of certain facts that are unique, in a sense, to this case. Your best hope is not to invite the tribunal to make some far-reaching policy determination that is going to shatter the world of arbitration, but your best bet in your client's interest is to formulate the straightest path for the tribunal to reach the decision that will help your client. That path is likely going to be exceedingly narrow. it will not involve massive jurisprudential leaps or innovative decisions on where arbitration should be in the next 15 years. It will likely be exceedingly narrow based on the particular facts of this case. That is not to say that it's supposed to be couched in exceptionalist terms, but your best bet is to make the arbitrators feel that they're doing something very modest, that they're taking a small step in simply applying existing precedent and practice, clear rules, to reach a result that the facts compel, not some shift in policy. You're not before the Supreme Court, you're not asking for a change in the law. So the plainer you can make your application seem, the simpler, the less dramatic, the better. Now, that isn't to say that you shouldn't also have a backup or an alternative route that gets you to the same result. There likely is one. There always is, because lawyers like to play it safe. But my experience is that if you have more than one, it gets a bit funny, at least as a decision maker, because you at some points wonder if the advocate still believes in the primary position, if they advance 14 alternative ways. So a scattergun approach will likely not work. Now, why would you want to do that? Now, there's a few points that I want to emphasize here. One is that it has to do with the arbitrator's mindset. As I told you, they're here to decide one case. They're not policymakers, they are service providers, dispute resolution service providers. And so anything that to them seems to be going beyond the boundaries of their mandate, that seems to involve steps that they are perhaps not accustomed to be taking, will likely make them very suspicious. You will also lose trust if you are not prepared to yield indefensible terrain, and to do so very early and very ostentatiously. Obviously, an arbitrator might well doubt you and doubt your ability to distinguish between what is true and what is not true. And that is lethal for an advocate. Being straight and picking a clear, defensible, narrow, fact-based path also happens to be simpler. If you're trying to advance some extravagant proposition, you will have to spend a lot of time on it because it's not obvious. You'll have to quote many cases, you'll have to explain why you don't agree with half of them and why the tribunal should prefer the other half. And at some point, it's going to be so over-engineered and so distracting that the tribunal might well feel that your case is without foundation, given that you had to work so hard to establish an implausible proposition. It's also safe to do so because, as you know, in a few weeks' time, some of your colleagues somewhere else in the world will assume the position of respondent and will respond to your memorial. And they will, of course, as you will, ruthlessly exploit any overstatements, any untenable propositions, any extreme statements of principle. And finally, you control the debate by not allowing the debate to drift into irrelevant and perhaps unwinnable points. You keep everyone focused on where you want to be. Now, how do you do that? Well, it's a lot of hard work and thinking, but I suppose you can go about it as follows. You first have to define with great precision what the issue exactly is on which you need a favorable disposition. And you should tell the tribunal what that issue is in the narrowest possible terms. You will then have to calibrate the rule, the relevant rule, in a way that lends itself to ready application by the tribunal. As you've seen, neither Article 23.4 of the ICC Rules nor any of the other provisions contains a detailed roadmap that a tribunal is to follow in applying these rules. So it's your job to look at the authorities, look at the practice that you have, look at the text of these rules, to figure out exactly what the tribunal needs to do with the facts of this case to reach that very small, tiny, narrow point. And then you focus the debate and you focus your factual material on that issue, on that issue only. And to do so, you have to be selective. You cannot quote liberally from all sorts of different sources. There are no prizes here for the most citations. I can assure you of that, and we'll come to that in a moment. Likewise, you have to select the facts very carefully. You have a strict page limit. You can't waffle on. So this needs to be completely concentrated. And you have to engage with the principles and policies that you identify. It is likely insufficient to simply say what the rule is and then list 4 facts. If it were that simple, we wouldn't have a moot. You have to show that you can work with the material rather than simply cite to it. Now, in so doing, you need to be extremely careful, because much like with your factual presentation and your handling of the factual material, arbitrators will rightly be unhappy if you are caught stretching an authority that you rely upon, making authorities appear to say something that they don't say, or supporting you in a way that they don't, or indeed trying to dodge or minimize both facts and authorities that are against you. As I say, a moot problem by definition is finely balanced, so any arbitrator would be surprised if you could tell him or her that this was a slam dunk case where all the authorities and all the facts were pointing in one direction and one direction only. Embrace the inevitable weaknesses. Embrace the aberrant decision that you can't use, but explain why it isn't going to hurt your case ultimately. Now, as you all know, being lawyers or law students, human beings do something very lawyer-like all their life when they try and construct an argument, a logical argument. And that's the typical syllogism. But funnily enough, as lawyers, we sometimes forget about this very basic, very natural process that makes us think that something is logical or inevitable or inescapable. When you construct your arguments on every issue or sub-issue, double check that you follow the 3 core steps on which every logical argument depends. The first one is perhaps one of the more difficult ones, which is to formulate your so-called major premise. In other words, the controlling rule. What is the specific test? What are the specific factors that the tribunal needs to scrutinize to come to a certain decision? Now, the sharper you can delineate that, the clearer you can demarcate the battlefield, the better. And it is here that you should find and engage with the very best authorities that support your proposition that this is the controlling rule. Once you've done that, the second step is to establish your minor premise. In other words, the relevant facts that engage the controlling rule. The factors or circumstances that connect, if you will, to what you've just said the tribunal must look at to decide whether or not to grant a certain application. Once you've done so, the third step is easy, because then the conclusion inevitably follows. But that process, as mechanical as it may seem, is behind every sophisticated set of legal reasoning that you will have in a brief. And the closer you can adhere to it, the better, the clearer for the tribunal to see, and the easier for them to integrate, if you will, into their own thinking process and their ultimate award. Again, that's not just me saying that. Others are too. And our friends from Freiburg, if you look at last year's winning memorandum for the respondent, did precisely that. And I'll give you one example here. This had to do with whether you have to prove corruption in order to get a stay of the proceedings while criminal investigations into corruption were ongoing. And the first step, of course, that they took was to explain what the relevant legal rule was. Don't know why my PowerPoint has disappeared, but there it is again. And they explained that the legal rule was permissive. They did not have to prove that these allegations were true, at least not conclusively so, but it was enough to establish that the outcome of the investigations was material to the tribunal's decision. Now, having established that major premise, if you will, they went on and showed in 4 steps why indeed the investigation or the outcome of the investigation was material to the arbitrator's decision. That's the minor premise, that's the facts, and the conclusion, of course, inescapably follows. Therefore, they were material, therefore proceedings ought to be stayed. It's as simple as that. Now, when you go about doing that, unfortunately, you can't simply rely on your friends at Kluwer or Vis Moot to give you the right material and all of it in a perfect, curated form. I just before this session typed in consolidation in Kluwer arbitration, and I got something north of 3,000 hits. And you can see for yourself how many commentaries and awards and court decisions this search engine threw up. And now, luckily for arbitrators, the Moot rules contain one rule that inevitably forces you to be extremely selective in what kind of authorities you pick, because you have to cite in the text. And as you can imagine, having citations in the text is, on one level, incredibly disruptive, because it disrupts the reader. The reader is reading a sentence, and halfway through, after a quote, follows a long string of citations. Now, if that's one line, that's bad enough. But if it goes beyond that, the reader will likely be somewhat disturbed. And rightly so. Either the proposition you're advancing is almost undisputed or difficult to dispute, and then a few really good citations should do the trick, or it is a very ambitious and controversial one, and then you might need to spend a bit more time to explain how you got there. Again, not by simply bombarding the reader with a 5-line citation. Now, I was told in advance that some of you may ask themselves, how on earth does this work in the particular universe of ICC arbitration? And I'll try and guide you through that process as best I can. The logical starting point, aside obviously from the parties' arbitration agreement or arbitration agreements as contained in the relevant contracts, is the ICC rules and their text. Now, it's probably useful not just to read the one rule or subparagraph of the rule that you are relying upon or invoking, but to read the rules more broadly to see also what the text may mean in its context. Now, as you know, the ICC is celebrating its centenary. So this year, so these rules have not come about in a vacuum. They are the product of a very long and distinguished history. And when the rules are being made or remade, that is often a very public process. So you are able to draw upon a very rich tapestry of institutional history that might help you understand a certain rule. And don't be fooled by looking at the 2021 rules. Now, certainly the rule in Article 23.4 is not a novelty. That is a rule that has been in the ICC rules for a very long time. And it might pay off, therefore, to look a little bit into the history of that rule and where it came from. So even older books, and I've shown you a few on the slide here, might contain helpful material to explain the background to that particular rule. Likewise, if you think about the ICC's practice on consolidation, while it is true that a codified rule on consolidation is a relatively recent invention, though not as recent as 2021, the ICC court itself has developed a very rich practice on this matter that stretches back far further than when the rule was first codified. So again, these are not fashions. These are long-standing features of ICC arbitration, and a lot of historical material, if you want to call it that, might therefore be very helpful. Now, at the same time, of course, you are living in an artificial universe where the UNCITRAL model law applies, and that may have some bearing on what you are arguing. Now, when it comes to what we would call precedents, obviously the best source will be ICC awards or procedural orders. Now, the ICC publishes them, not all of them, of course, but in great number, sometimes in thematic series, sometimes as part of their bulletin. And again, that is a practice that stretches back many, many decades. So you will be able to find a whole range of procedural dispositions in various formats from throughout the ages, if you will. And that is true for other institutions as well. I've listed a few here just for illustration. That they might have something relevant to say, but bear in mind that the ICC rules are in some ways idiosyncratic, and you should always be attentive to the differences in the overall structure of the rules and, of course, the particular rule that you're working with when you look at decisions from further afield. The third layer is the enormous range of commentaries that you have, not just on arbitration in general, which of course is very helpful, and I'm sure you've all made the acquaintance of Professor Bourne and other luminaries, but the ICC, being the global institution that it is and having been around for so long, has generated an enormous amount of literature around it. I think there's no other institution about whose rules so many commentaries have been written over time. And again, some of them are very recent or have recently been updated. Some of them are a little bit more dated. But for the reasons that I just mentioned, all of them may have something to say and may help you in establishing exactly how, say, Article 23.4 of the ICC Rules is designed to operate. And for good measure, I've included one non-English commentary in my little list here, just to illustrate the point that there are also many international commentaries that are not drafted in English, but in other languages, French, German, Spanish, that you might find useful to consult. Now, for good measure, and just so we remember that we're here to win a case on the merits as well, the same is of course true for the CISG. I'm told you are far more in control there, but it's a similar approach, I would say. Your starting point inevitably is the CISG and its rich travaux préparatoires and the institutional commentaries that will tell you what the drafters of the CISG were having in mind. The layer beneath that are court decisions, judgments from the relevant jurisdictions, and then of course you have again a very broad range of commentaries. Now, I should tell you one thing, and that is, because you are going to find 3,000 documents on Kluwer on the issue of consolidation, you have to be extremely judicious. And likewise, when you look for relevant judgments under the CISG, selection is key. And perhaps it's also relevant or helpful as a general rule to be a tiny bit, well, let's say conservative in what you think you should listen to or what you think the tribunal should follow. Obviously, a tribunal is going to be interested in, say, what another ICC tribunal did in another case. And likewise, any tribunal will be, no doubt, fascinated to hear how the German Supreme Court or the French Cour de Cassation decided a certain issue arising under the CISG. Obviously, a tribunal might be less impressed if one of your central proposition is based upon a first instance judgment from a remote jurisdiction or an article that you have found, but nothing else than that. Arbitrators like to do it, like to play it safe, if you will, and the better the support you can offer them, the higher chance of winning. If all you can find is some dodgy district court from the Netherlands, you may be arguing something which is difficult to sustain. Now, again, for a final time now, our friends from Freiburg, see what they did in the very passage that I showed you at the outset. They rightly, in my view, begin with the text of the relevant rule that they say gave the tribunal the power or the discretion and the power to stay the arbitration. And then they supported their formulation of the test in two ways, and I think it's good to look at that little string of citations and to see exactly what they did. They began, and that's the part in, I think it's blue on my screen, they began not with a general textbook on arbitration or some article that they had found somewhere, but they started off with procedural orders that had been issued in other cases. And they were very clever in the way they sequenced it, because they didn't begin with the ICC or the London Court of International Arbitration, because last year's institution was the PCA, so the PCA rules applied. And so naturally they selected a number of PCA cases from which they had found procedural orders to illustrate their proposition. They did continue showing other or referencing other institutions as well, but they carefully organized these sources in a way to signal to the tribunal that other PCA tribunals had done precisely what this PCA tribunal was also being asked to do. And they finished the citation with two references to specialized literature. Again, not general books, general commentaries that cover everything, but two specialized sources. Now that is commendable moderation. No doubt what is being put forward here in paragraph 38 is something you can probably find in many general works, in perhaps even some court judgments, in procedural orders from other institutions. But all that, if you put it in this citation or string of citations, would of course make this unmanageable. So this degree of selectiveness is, I think, what I would recommend you also apply to your own work. Now, I've spoken for way too long now, and I know that people are apparently really keen to ask questions. So here's my surprise for you. Part 3 is dedicated to me listening to your questions and then answering them as best I can. Thank you very much.
Thank you so much, Matthias, for that very elaborate discussion. Yes, as you've intimated, we have questions from some of our students, and I'll get right into it. The very first question from our student is, you've talked about the need to be extremely judicious while choosing authorities. Yes, and this particular student is interested in knowing that what is the best way to go about comparing and contrasting authoritative views in a particular instance where there is, let's say, a majority opinion and then there is a minority opinion, but the argument they want to advance is for a minority view, and there are scholarly articles in support of this particular position. So what's the best way to go about that? I don't know how we're going to do this, whether I go all in and give you a number of questions and then you respond, or...
No, I think you can do it, otherwise I'll forget. But so I'm happy to deal with that one by one, right? So this is if you're trying to push a minority view, the first one is make sure it's really a minority view. That is sometimes a bit difficult to ascertain in international arbitration. And I've always been struggling with the idea of a minority view. But let's assume that it is. Then I think the better way to think of this is not as majority versus minority, but as the general rule for most cases and a slightly different or special rule for particular cases. So I think your task or your challenge is then to explain why this case, your case, is sufficiently different from the average case that it justifies the application of a slightly modulated rule and not the general rule. So I think it's in the same way that in a common law system you would distinguish precedents and you would try and show why your case is not quite the same as the case that was decided before. You would do the same thing here, but perhaps do it on a slightly more systemic level and focus on the broader reasons why cases like yours or like this one should be resolved by reference to a different or slightly differently configured rule.
Thank you, Matthias. I think we shall take a question from one of our students. This is Conradus Kakoko, and he's interested in knowing how do you balance the way you present your tone, consistency, and mode of your argument without being affected by the interest and incentive of the arbitrator. I do not know whether this is very relevant for our written memorials, but maybe you would give us your take on that.
Yeah, no, it's always good to start thinking of Vienna early, because it's also the funnest bit, right, of it all. Yeah. And sadly, I have to disappoint Conradus because there is no hard and fast rule. What I will say is that you shouldn't have an immutable battle plan, because you will go into a hearing and you will meet three people that might completely surprise you. Now, when I coached the Moot many years ago, my students for their first hearing in Vienna were ready to go. They were prepared for every question. They were going to engage with this tribunal, and they were going to charm them into the ground. Mm-hmm. And we walk into that room in Vienna, and the tribunal, I kid you not, consisted of three Finnish gentlemen who didn't smile, who didn't say a word, didn't have a single question, who just sat there and stared at them. And my students had to make the mental switch from the posture they had been trained to adopt in all the pre-moots, where everyone is so excited and asks a million questions and gives you a hard time, and just speak to these three very stoic, attentively listening individuals. So that's an illustration perhaps of my point. At the same time, you can see, on the other extreme, very interventionist tribunals, etc., etc. And all you can do, I think, is be yourself, go with the flow, and in a sense, as I said, help them. If they are pushing you, if they are asking you questions, if they are showing that they are unhappy about a certain point, they're not there to torture you. They're illustrating or they're communicating that they're struggling to see things your way, and they're asking for your help to put them back on the right path. It's not an exam, an oral exam. It is a dialogue, and as long as you keep thinking of the interaction you have as a respectful dialogue between equals, intellectual equals, I think you'll take the right approach.
Yeah. Thank you, Conradus. I hope you've gotten that the hot and cold tribunal dynamic. Yeah, it's better to prepare for both. Moving on to our third question for today. Our third question for today is, you talked about the fact that the audience, the Vis Moot audience, is not exactly homogeneous. You're dealing with people from different jurisdictions, so considering the range of legal traditions is quite wide. So what is the best hierarchy of authorities to cite in support of your argument? Yes.
Yeah, no, I think I tried to convey that, and I think that the point is to blend, if you will, the best of civil law and common law reasoning, which I think also happens in arbitration in real life, and that is, I think, logically always begin with and try and be strong on the text of the rule, if you have it, and deduce whatever you want to deduce from that text. I think the second layer, and that's what I thought to show by reference to the examples from the last edition, was an arbitrator will, I think, be most receptive to being told that his arbitrator friends or her arbitrator friends in other cases have done exactly the same thing. That feels safe, right? That feels like, this is a prudent thing to do. Apparently, everyone else is doing the same thing, so it must be okay. Hence, I think my illustration of that point by showing that the first source or set of sources being cited in that memorandum were procedural orders issued by tribunals acting under the same set of rules. So in this case, I think if you could find POs issued by ICC tribunals, they would be, I think, great to help illustrate the point. And then in the layer below that, I think, is if you really have to, and it helps sometimes, and it's sometimes also a question of how it is expressed, would be commentaries or other publications. Again, I would be very careful there. I think very few things can be derived from general publications because they often contain very general statements, and you don't really need a source for very general statements. So you're likely to find more or more helpful stuff in more specialized publications, be it ICC-specific commentaries or articles in the ICC Bulletin or reports of the ICC Commission on Arbitration. They are likely going to give you more specific and more pertinent fodder than a kind of very general book that talks about, say, consolidation in very general terms. So I would say that would be, for me, a hierarchy of sources and authorities. And in the ICC, in the CISG context, I think I try to do the same thing. Now, the CISG is something where you have a lot more commentary being penned by civil lawyers. So everyone knows Schlecht-Riemann-Schwenzer, everyone knows Schröter, everyone knows Kröll, all these big books. Now that is heavily civilian, right? So bear that in mind. But here again, you have, thanks to all these databases, you have a rich repository of case law, and there I would suggest to gravitate towards the more senior courts, the higher courts, the appellate courts, and sometimes a lower court decision can be helpful because it illustrates a point, but it's rarely the best authority you can get to make a substantial point of principle.
Thank you, Matthias. We have another question from one of our students, and they're very interested in scoring high memorandum marks. So
very good.
Yeah. So the question is basically that is it material that one refers to decisions from across multiple jurisdictions? Of course, there is a tendency to cite decisions that are closer to home. Let's say you come from an African country, so you'll gravitate more towards decisions from your Supreme Court or maybe the neighboring jurisdictions. So is it very material that you refer to decisions, let's say, from Latin America, Asia, Europe, and the Americas in order to score high marks in a memorandum? Do they consider that?
Well, I think, again, in principle, you're not graded on how many decisions you can find and cite, right? So I don't count it myself. I think sometimes it's an important device to show that a rule you're saying exists or proposition you're advancing enjoys sort of global support, right? Certainly, the CISG is, as you all know, is supposed to be interpreted autonomously, right? It's not supposed to be a different CISG in Germany as compared to the Netherlands or as compared to an African country. And so, if it's a really controversial point, it might make sense to say, look, this is what the rule here is, and courts everywhere, more or less, agree with that or have endorsed that view. So I think that can be useful. I think I wouldn't do it as a matter of course. I mean, there's also a risk of having too many citations and having fairly general, easy scoring points supported by long strings of citations when you wonder whether, maybe 2 or 3 wouldn't have been enough. So I think pick your battles, if you will. If you really want to drive home the point, then by all means show that it's widely supported. But I wouldn't do it as a matter of course for every single issue that comes across or that comes up in this problem.
Okay. Thank you for that. And then lastly, for today, we have Chris Clowet. He is really fascinated with your career path. So he's interested in knowing, he's interested in what are some of the differences between working for an institution? You have a background working with the PCA, the ICC, and in private practice. And how does one help the other? So I think we are dealing with a career path sort of student. Yeah.
Yeah, it's very, very different. So being in private practice is quite unlike being in an institution, but I think it's extremely invaluable to have seen it from, if you will, the other side. Why is that? Now, first, as a lawyer in private practice, you only have so many cases at one time, right? My day also only has 24 hours, so I'll handle a few cases at the same time. They're all very big. They go on for years, and that's great. At an institution, you inevitably see a lot of cases coming past you at a great pace. As I said, at the ICC at the time, the team that I was leading had around 200 active arbitrations at any given moment in time. That's a huge sample, if you will. And so you get to see from a very interesting neutral position not only what arbitrators are doing, which is fascinating as an insight into how indeed things happen behind the bench or on the bench, but also how counsel in that great range of cases conduct themselves and conduct the proceedings. Because as you know, at the ICC, not only do we have a lot of procedural decisions to take or to assist the court in taking, but you also get a copy of everything, every submission, every decision, everything. So you have a huge amount of data points, if you will, to think about what is happening here in practice. It also means, both at the ICC and at the PCA, that you work in an extraordinarily international institution. So you often come there as a young arbitration lawyer, and you have your jurisdictional biases. I had certain views on how arbitration should work based on my jurisdictional biases, and then you are exposed to this group from all over the world who will look at you and think that you are slightly crazy because they see it very differently, because in their home jurisdiction you would look at the very same issue very, very differently. And so that is another part of the excitement, I suppose, and of the value that you derive from working at an institution. At the PCA, I suppose, as you may know, the work there is slightly different at times, in the sense that the PCA also acts as registry in these big arbitrations, which means that you're working together with the tribunal and you're assisting the tribunal in discharging its mandate. You're helping with their work like a tribunal secretary. So you get an even more intimate view of how a tribunal composed of very eminent people, in front of whom you might be appearing in a few years, is looking at cases, is thinking about cases, is reasoning, is deliberating. And all of those experiences and all the friendships you make, let's not forget about those, are massive assets, I think, both personally and also professionally. So I wouldn't really want to miss my time at the ICC and the PCA. They were formative years.
Okay. So thank you so much, Matthias. So I'm giving it over to Erin.
Thank you very, very much to both Matthias and to Annie, of course. I think it's really a wonderful testament to one of the objectives of Africa in the Moot, which is to promote diversity and equal representation, but also globalization of international arbitration. By that, I mean by having someone with your own diverse experience, being able to share that experience with, indeed, our very diverse pool of students. So thank you very much for sharing your insights. I hope that those who have been watching and those who will be watching the recording later on will certainly gain the value from the session as was intended. And apart from thanking Matthias, of course, and thanking dear Annie, I also want to thank the Arbitration Channel for very kindly hosting this session for us. We're forever indebted to you. And with that, I want to wish also the students very, very good luck in the remaining 10 days before your submission is due. I also will take the liberty, I have not sought his consent, but I will take the liberty to encourage you to please reach out to Matthias if you do have any questions relating to careers in arbitration or in respect of his extensive resume, as I said earlier in the call, about with his legal practice, but also in his time in the moot. That is very, very valuable. So please do take that liberty indeed through LinkedIn and however you see fit. And bug him if you see him in Vienna next year. I'm sure he will be happy to be bugged. But with that, we close the session, and we will see you again soon for the 7th session of this education series. Have a good evening.